foot and hand. Victim stated suspect was approximately 2 steps in the apartment and any entry of any part of the body, be it a window or whatever, that's burglary of habitation. Victim stated there was a verbal altercation between the door while holding back suspect from making further entry.
This case looks simple at first. A mother, a child, and a late-night search driven by fear. But within minutes, it turns into a felony courtroom proceeding with life-changing consequences. One decision made under pressure leads to a charge that carries up to 20 years in prison. The judge in this courtroom doesn't deal in sympathy, only facts, law, and accountability. As this hearing unfolds, you'll see how emotions collide with legal boundaries and how a single moment at a front door can redefine someone's future forever.
All right, court is calling 2025 CR 0035550 State versus Leslie Martinez. Can I have parties announced?
Rick Pena for the state of Texas.
Jim Oltersdorf for Leslie Martinez.
Are you Ms. Martinez?
Yes, ma'am.
Did you understand you're charged with burglary of a habitation? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
All right, off the record for a moment. Oh, they were saying it was a false alarm. We're back on the record.
My wife is outside. She just let me know.
Okay. All right, we're back on the record. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Then to paragraph B in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
So, counsel, I can sentence her today and order her to be back here on court on Thursday, and they will give a victim impact.
That would be fine, Your Honor. May I ask that the court may consider for the fact that I'm court appointed with regard to the fine, maybe probating a portion of the fine?
Yes. All right. So why did you go over to this house?
So I was looking for my son. His dad had taken him, so I went to look for him at his aunt's house because I thought they were there.
So why do you need to look for him? Because he has your son.
Because it was we had a fight, so he didn't leave in good terms. So I was worried about my son.
All right. So this is what people need to understand, and I don't think people understand this. Even though you're a mother of the child, that's the father of the child. And when people have a child and the father takes the child, sometimes mothers feel as though, well, I'm 100% should have the child, and he should only have the child when I say so. Unless you have civil documents that say that, that's not the case. So you're entitled to have the child, he's entitled to have the child.
This is where the court draws a hard legal line. The judge carefully explains something many people don't understand. Parenthood does not override the law. Without a custody order, neither parent has superior rights. The court makes it clear that frustration, fear, or anger cannot justify taking matters into your own hands. This moment reframes the entire case. What the defendant saw as a desperate search, the law views as a violation of boundaries. And from here forward, intent becomes far less important than conduct.
People will be responsible adults and they won't be running around, causing problems or taking a child out of frustration or anger. You have to remember, the father of your child is the person that you chose. You thought this would be a great person to have a child with, and so that's the father of your child. Now, it says in here that she told you that her brother wasn't there and the child wasn't there. So why are you still trying to force your way into the apartment?
I was not trying to force myself into the apartment.
Well, that's why you're here. It says, victim stated to me that on July 17, 2024, around 050 hours, suspect made the location. And that's military time, so not a good hour to begin with. Victim stated that she was awoken by hard banging on her front door. Victim stated she opened the front door thinking it would be her mother. Victim stated when she opened the door, she noticed the suspect, that's you, who appeared to be intoxicated, who told victim she was looking for victim's brother and her child. Victim stated she advised suspect they were not at the location and for the suspect to leave. Victim stated she attempted to close the front door. Victim stated suspect began to force her way into the residence and made entry via her foot
This is
and
the
hand.
most critical legal explanation in the entire hearing. The judge spells it out plainly: burglary does not require theft, and it does not require full entry. Even a foot, a hand, or a partial step into the home is enough. That detail alone changes everything. Add alleged intoxication, physical resistance, and visible injuries to the resident, and the case escalates quickly. At this point, the courtroom tone shifts. This is no longer a misunderstanding, it's a felony defined by statute, not emotion.
Suspect was approximately 2 steps in the apartment, and any entry of any part of the body, be it a window or whatever, that's burglary of habitation. Victim stated there was a verbal altercation between the door while holding back suspect from making further entry. Victim stated suspect caused bodily injury when she elbowed victim and caused the door handle to hit victim in the left buttocks. Victim stated there was shoving and pushing with the door between the victim and suspect. While speaking to the victim, she was able to show me bruising on her left forearm and a photograph of the bruise on her left buttocks. Victim stated witness woke up and assisted victim closing the door. So maybe you don't remember, they say you were intoxicated. So here's the thing, when people don't want you at their home, regardless of what it is, you don't force yourself in. If you think your son is there, you think your son is in danger, which it doesn't appear to be because you were intoxicated, you need to call the police.
Yes, ma'am.
So, do you have custody of your son now?
Yes.
And the father of your son, does he see your son?
Yes.
No problems? Now you're here with a felony hanging over your head.
Yes, ma'am.
So is this the only child you have?
Yes.
Are you employed?
Yes.
What do you do?
I work at a call center.
Doing what?
We ought to make appointments for hearing aids with Miracle Ear.
Okay. Any drug use?
No.
Any alcohol use?
No.
You're not allowed to drink any alcohol while you're on probation. Do you understand?
Yes, ma'am.
All right. There's a $1,500 fine that will be probated. There's to be no contact, regular reporting by Zoom or in person, regular random UAs, 5 years deferred adjudication, 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied, and anger management classes.
Now the court turns from what happened to what comes next. Employment, sobriety, parenting classes, anger management. Every condition reflects the court's attempt to prevent this from ever happening again. But make no mistake, this is not leniency without limits. The judge is offering structure, not forgiveness. The defendant's future now depends entirely on compliance. One violation, one bad decision, and the deferred adjudication disappears, replaced by a permanent felony conviction.
Probation is in field visits 1 time per month for 3 months. Probation, is there anything else? Sorry?
Employment.
Oh, thank you so much. Proof of employment within 30 days, no employment as a home health care provider or with minors. Is there anything else, probation?
No, sir.
All right, anything else you need from the court?
No, ma'am.
All right, we can go off the record. So, State, here's the thing. I know the sister, I'm assuming she's the sister of her boyfriend.
Sister-in-law.
All right, so
Sister.
you may want to talk to her. I don't know if the brother wants her to do a victim impact statement with her, but if they are all trying to be a family, may not be the best. But if she does, this is going to come back. You're going to be back in court on Thursday to hear her victim impact. Do you understand?
Yes, ma'am.
All right. Norma, if you'll give her a reset for Thursday, if there's anything else you need?
No, ma'am.
All right. On
Placed
probation to be
after
successful.
7:45 end of hearing. This case is a powerful reminder that good intentions do not cancel illegal actions. The court acknowledged the emotional background, but ultimately enforced the law as written. A single night, driven by panic and poor judgment, placed a mother's freedom and her child's stability at risk. The judge offered a second chance, but with strict conditions and zero tolerance for failure. Backhand index pointing right if you found this courtroom case as intense as we did. Make sure to hit the like button, share your thoughts in the comments, and subscribe for more real courtroom breakdowns and legal analysis.